Good afternoon, colleagues. Pursuant to order of reference of Tuesday, April 25th, 2006, and Section 29 of the Personal Information Protection and Electronic Documents Act, we're conducting a statutory review of Part 1 of that Act. Today, our witnesses from the Office of the Privacy Commissioner of Canada are Ms. Jennifer Stoddard, Privacy Commissioner of Canada, Heather Black, Assistant Commissioner PIPEDA, and Melanie Miller-Chapman, Strategic Research and Policy Analyst. Welcome to you. We understand that, Commissioner, you have an opening statement, and then we'll go into the usual questioning. Is that correct?
If that's convenient for you, Mr. Chairman, yes.
Please carry on.
Okay, I have a fairly short opening statement, and we've got a good time for questions. Alors, Monsieur, Mesdames les députés.
Ladies and gentlemen, members of the committee, I'm very pleased to be here today to assist you with your review of the Personal Information Protection and Electronic Documents Act, or PIPEDA, as it is commonly called. Our privacy is fundamentally important to all of us, as consumers, as citizens, as students, as employees, in every aspect of our day-to-day lives. The Act, along with the Privacy Act that applies to federal departments and agencies, provides the foundation for privacy protection in Canada. I'd like to take a moment to explain why PIPEDA is more important than ever. When we first started talking about this law in 1998, the information highway was a catchphrase. Now it's a reality. Transborder flows of personal information were a trickle back then, but now they're a flood. New and emerging technologies such as location tracking devices and radio frequency identification threaten privacy in ways that were unimaginable a decade ago. We want to help you in this critically important task of ensuring that PIPEDA remains capable of dealing with the many privacy challenges we face in the 21st century. In preparation for the review, we issued a consultation paper setting out 12 issues that we identified as worthy of attention. We received over 60 submissions from a variety of organizations and individuals, and a summary of these submissions, along with a discussion of the issues we identified, are included in the submission we've tabled with the committee. I think it's fair to say that there is a general agreement about the issues the committee might want to consider, but unfortunately, there is no consensus about the best way to address all of these issues.
That I want to leave with you today. We believe that PIPEDA is generally working well. PIPEDA strikes a careful balance between two goals: the right of individuals to keep their personal information private, and the need of organizations to collect, use, and disclose personal information for purposes that a reasonable person would consider appropriate. I've chosen the following issues to bring to your attention today because they have the potential to affect the privacy interests of a large number of Canadians. First of all, it is important that privacy law be administered in a stable context. PIPEDA is based on an ombudsman model. As Privacy Commissioner, I have the power to investigate complaints, to conduct audits, to make findings, to issue non-binding recommendations, and initiate court actions. We will not be asking for enhanced enforcement powers. We are not convinced that the time is right to make such a fundamental change to the enforcement mechanisms for several reasons, both practical and administrative. Secondly, some of the most difficult complaints we have received have involved employee information. PIPEDA is based on consent, which is a challenging concept in a workplace environment where there is unequal bargaining power. One of the issues that you may wish to consider is whether there are more appropriate ways to deal with employee information without sacrificing the privacy rights of workers. Our submission offers some suggestions about dealing with employee information. With respect to the issue of work product, PEPIDA does not use the term. We've addressed this issue by adopting a case-by-case approach to assessing whether or not the information in question is about the individual. If the answer is yes, then the information is protected by the Act. We recognize that an individual in his or her capacity as an employee or as a professional may generate information that is not about the individual. We would caution you that removing all such information from the Act could result in intrusive workplace monitoring and other abuses. Depuis l'adoption de la loi, les préoccupations relatives.
Since the Act was passed, concerns about protecting trans-border flows of personal information have taken on a new urgency. As a result of globalization, the emergence of new follow-the-sun business models, and the explosion of offshore processing, the amount of personal information flowing across borders has increased dramatically. At the same time, governments are increasingly interested in obtaining access to this information for national security purposes. PEPIDA does not contain any specific provisions with respect to trans-border information flows. We believe that by providing guidance requiring organizations to be more open about their processing practices and holding them responsible for personal information when it crosses borders, we can address the challenges of trans-border information flows. We also need to ensure that we can deal with complaints that involve other jurisdictions. We live in a world of increasingly virtual borders in which privacy issues do not always respect national boundaries. I would ask you, ladies and gentlemen, members of the committee, to consider a specific provision to make it clearer we have the authority to share information with our international counterparts while cooperating on investigations of mutual interest. The Act requires organizations to protect personal information from unauthorized access or disclosures. The Act does not require organizations to take any specific actions in the event of an unauthorized disclosure. More than half of the U.S. states have passed laws requiring organizations to notify their customers or clients when their personal information has been compromised. Policymakers in the European Union are looking at similar requirements. Breach notification laws may force organizations to take security more seriously. They may provide individuals with an early warning system to make them better prepared to deal with the risk of identity theft and other harms that might result from a privacy breach. We look forward to discuss with the committee whether it's possible to fit a notification requirement into the framework of the Act.
Chairman, I'd like to raise one very specific and I think pressing matter which relates to a recent Federal Court of Appeal decision. This case deals with solicitor-client privilege and our ability to obtain access to documents in the course of our investigations. This recent decision in a case called Blood Tribe leaves a gaping hole in our ability to conduct meaningful investigations. It effectively allows organizations to shield information from our investigators with no independent verification that the documents in question do in fact contain information subject to solicitor-client privilege. Although we are seeking leave to appeal, we believe this ambiguity in the legislation needs to be clarified with an amendment to PEPIDA as soon as possible. So to repeat, we believe that PEPIDA is working reasonably well. Overall, we think that there is a high level of compliance and that the business community is committed to the protection of our personal information. Can the Act be improved? Yes. Based on our experience in applying the law since 2001, and with benefit of the second-generation private sector laws that have been passed in some provinces, we have identified in our submission gaps in the Act and provisions that would benefit from greater clarity. We think there are ways in which the Act can be made more practical and more predictable. And so after you've had the benefit from hearing from doubtless numerous other witnesses that you may call before you, who may appear before you, we would ask to come back at the end of your hearings, Mr. Chairman, in order to give our final view on the various matters that are being put before you. Thank you.
Thank you very much, Commissioner. Now we'll commence our first round of questioning. We have a full docket of questioners and 7 minutes in this round. We'll start with Mr. Peterson.
Thank you, Mr. Chair, and thank you, witnesses. What type of amendment would you envisage to get around the blood tribe decision?
They would be a very specific wording amendments that makes it clear, and I think the model is in the Privacy Act, to make it clear that our investigative powers are not blocked by solicitor-client privilege. This was, as I understand, this is in the Privacy Act, and it was not, we understand, put in PIPEDA because it was thought that our investigative powers were clear enough. There seems to be some ambiguity, so we would look to the Privacy Act as a model.
Do you envisage any objections to that type of amendment?
There might be, yes, there might be.
You floated this suggestion before. Have you received any objections?
No, we have not floated it before, Mr. Chairman. We only received this decision about 3 weeks ago, I believe, as a decision of the Court of Appeal. The first level of the federal court was in agreement with us that our investigative powers included looking at documents for which it was alleged there was solicitor-client privilege. The Federal Court of Appeal disagreed with that, and so this is now the first time we have asked for an amendment.
Can you give us some examples of how that's going to hamper you specifically in the work you're doing?
Well, we think that there is a very real possibility that that respondent organizations could take a very expansive view of what solicitor-client privilege is, and thus, in fact, shelter documents containing personal information that would be appropriate to our investigation behind the use of this privilege.
What type of, can you give us a sense of how many complaints your office has received since
the beginning
I don't even know how you pronounce this thing, but
can you find that for me?
PIPEDA, or what are you doing? Okay.
Yeah. I believe it's overall about 1,400 complaints, Mr. Chairman. Let me
Over
just,
3.5 years.
No, over the 5 years now that it's been in force. Let me just find those statistics for you. I can give you, we've received over 56,000 inquiries. That's written and telephone inquiries. And let's see, I'm just looking at the number.
You could get us this information later.
Yeah, it's about 1,400.
Is there one type of complaint that dominates?
Yes, the complaints are mainly about use and disclosure and collection. Those types dominate from year to year, and access, those three types. First of all, use and disclosure, 38%. Collection is 23%, and access to one's own file with one's own personal information is 18%. Okay.
How many times have you had to go to court?
I believe we've been involved in some 50 cases since the inception of the first stage of PIPEDA. We're currently at the federal court in 12 active cases.
How long do each of these cases usually take before this determination, final determination?
It's hard for me to answer. I haven't really measured that.
I imagine it'd be substantial.
Before the federal court, you mean?
Yeah, be a substantial amount of time before you could get to court and get heard and get ruled on, wouldn't it?
Well, the statistics over the last 5 years show that on the average we have disposed of the complaints under PEPITA in under a year, around 11 months on an average. The time then to go to federal court, or the time before federal court, of course, as you know, would depend on, how quickly both parties move and where the hearing is and various other things like that.
You say in your excellent memo to us that you don't want order-making power because you want to continue on the course you're on. And if this means then you're probably happy that having to use courts to resolve certain issues?
I think, Mr. Chairman, that this is not the time to make any major changes in the framework of PEPITA. As this committee will remember, certain members of this committee, this law was applied in less than ideal circumstances at the beginning. It's been a very difficult road for the Office of the Privacy Commissioner. That is one hand. On the other hand, I don't think that we have any really serious study about the advantages and disadvantages of various models of enforcement. And thirdly, I could say, Mr. Chairman, on that we have quite a wide range of powers, and that going to the federal court is in fact a very strong power, because an order of the federal court is an important order in the hierarchy of legal orders. So that for all these reasons, I'm happy at the present time to go to federal court.
Even though it's slow and cumbersome and costly?
Mr. Chairman, I say I don't know. I have nothing that leads me to believe that this is slower or more cumbersome than going before equivalent tribunals. And I have some knowledge of tribunals from having administered tribunals. It's, depends on the requests for stay of proceedings, depends on the availability of parties, depends on, where they can be heard. So I think that there aren't excessive delays at the federal court. I don't think that we have to wait excessively long to be heard. And most of our cases are settled out of court. And in fact, if I could conclude on that, Mr. Chairman, when we, as we have in the last year or so, have in essence turned up the heat and said, if you don't comply to our recommendations and come into conformity with the law, we would take you to federal court. I think all but one organization has complied.
Now, two of the provinces do have order-making power, don't
Yes.
they? I'm sorry?
Sorry, Mr. Peterson. Thank you, Mr. Tilson. You're right on 7 minutes.
Oh, thank you.
Madame Lavallée.
Thank you. Welcome, Ms. Commissioner, and please take your time to put on your earpiece. No, it would be more for the acoustics. Thank you so much for being here this afternoon to present us with your suggestions as to how to update the Act. In fact, many of your suggestions are very interesting, and you point to the issues of the day. One thing you said in your presentation, I'll try to find it here. You say that there is a huge increase in trans-border flows of personal information. And you also say that there's nothing in the Act which addresses these trans-border flows of personal information. Is that correct? Because of this globalized flow of personal information, that really didn't exist to the extent it does today when the Act was passed in 1998. And I don't have a clear directive. I don't find a clear directive in the Act to deal with my counterparts, to deal with issues, problems in a very clear manner. If there's any change I would like, it would be that the Act clearly tell me how to deal with a complaint and the details of a complaint with my European Union counterpart if, of course, we're dealing with personal information. You said that you meet with EU officials or your American counterparts. Is that correct? Yes, yes. But you want to go even farther? Do you want to be able to negotiate with them? Is that what you're saying? We want to stay in general areas of interest. We do not want to provide personal information to another country, and we'd like some more specific guidance. If, for instance, our French counterparts are dealing with personal information, we want to be able to deal with these trans-border flows in a very clear manner. I'm sorry, I'm new on this committee, and I'm not quite sure I understand what you're saying. Are you saying that in the case of a complaint, you should be able to deal with your EU counterparts to conduct a joint investigation on a complaint? Absolutely, yes. We want to be able to transfer a file to, for instance, our EU counterpart because they are the ones who should deal with the issue. And this is not stated clearly in the legislation. The Act speaks very generally to that, but I want more specifics. In fact, that's not quite what I had understood. I thought that you wanted us to find ways to better protect the personal information of Canadians and Quebecers when this private or personal information flows across the Canadian border. I thought that was your concern. Sure, it's another one of our concerns. We've discussed this matter at length. You may have heard several points of view on this particular issue. We are saying that it is possible to include general guidelines in the Act as issued by the Canadian government, or rather recently by Treasury Board in its guidelines for the private sector. We have the principle of responsibility or accountability in the Act, and it is there to encourage companies which export information on Canadians to get the organizations or companies they send the information to abroad, to get those companies to abide by Canadian standards. And this accountability principle is spelled out clearly in the Act, but it's also fairly flexible. To address that issue, are you saying that additional guidelines should be included in the Act? Well, we can already deal with the problem by virtue of this accountability principle. Are you talking about Bill C-2 when you talk about accountability? No. This is principle number 4. Principle 4 is included in the CSA code. The Act was based on the standards contained in the Canadian Standards Association Model Code, and so the use of private information is regulated by these principles. And the first principle is the principle of responsibility. So if I work for a Canadian company and I send data on Canadians abroad, I remain responsible for that information here in Canada. Thank you. That clarifies the matter for me. You also talk about the disclosure of private information, and you say it would be interesting to include something on breach notification or a notification requirement. Yes, this is not spelled out clearly in the Act as to how to deal with accidental breaches of information. We agree with the principle, but how to apply it is the problem here. Would you have an idea of how to implement it? Well, we've turned to the American model, and I think that we should get government lawyers to study the matter because it is extremely complex. They can give us an opinion on how far these notification requirements should apply to a certain type of information, who is to pay for it, and so on and so forth.
Could you give us, if not now, could you send to us the exact section of the Privacy Act that you are suggesting that we import into
Mr.
PEPITA?
Chairman. Yes.
Thank you. Mr. Martin.
Thank you, Mr. Chair and Ms. Stoddard. Good afternoon. I'm interested, if I could jump right to the paragraph in your document from July that you circulated for comment, dealing with the fact that, and I'm actually quoting from your document, by the end of 2005, roughly half of the United States had passed laws making notification mandatory if your personal information has been compromised.
Yes.
I'm most interested in that, and I'm wondering what your current views are, if that is something you would strongly recommend the committee to look at, mandatory notification.
Yeah. Yes, Mr. Chairman, this is something that we suggest that the committee do add to the Act. This has become an important problem. It's become, we think, a source for identity theft, although there isn't a lot of work done linking identity theft to the data spills, but it can't certainly, it must contribute to it. So we would suggest that you recommend that there be a breach notification provision in this law. However, the exact wording of the breach notification is honestly quite a challenge. We looked at almost all the American models, and there are quite a few variations on it.
Do you think that it should be graded on how serious the breach was? Well, for instance, I've heard that one of the credit card companies that I won't mention because for commercial interests had over 3 million breaches or compromises that they haven't notified their clients about, but some of those may be a matter of pennies that was quickly corrected. Would you try and gradiate the severity of the incident as to what would have to be reported?
I would think that you'd want to put in some criteria like significant. You know, you can have a technical breach of personal information, but if it's not significant, then you get into a company having to notify millions of people, which is extremely costly when, from the company's point of view.
By the same token, those millions of people have a right to know if the credit card they're using is being regularly and frequently compromised.
That is, but if it's not necessarily significant, and then as I say, it's not clear the exact links between breach notification and identity theft. In fact, I haven't seen any studies. Perhaps some of your other witnesses will know about that. So you can't say, well, because of this breach, we know that these numbers of people whose... So I think there are some of the states whose models seem to us more workable. We could come back at the end of your hearings and see which are the better ones. I don't know if the Assistant Commissioner has any comments on this.
Well, I mean, I think it's an interesting question and something that we have spent a lot of time thinking about and looking at. In the question of credit cards, it's probably happened to you. I know it's happened to me. I get a call from the bank saying, did you charge, so much in a saloon in West Texas? And gosh, no, I was here in Ottawa. So, it's in the interest of the credit card issuers to keep track of these things, and they do it actually quite well because they pay. You don't pay, they pay, because your liability is limited. So, you mentioned the 3 million, I think, at one of the earlier hearings, and we tried to track it down and couldn't find it. So,
I see.
It's really hard to know what kind of breach that they're talking about.
Yes. Okay, that's very helpful. If I have a minute left, there's two other issues. Oh, what a luxury. There's two other issues that have interest, and I think I've mentioned this at other meetings too, but I know the province of Manitoba contracted out their health data information to a private firm. that firm was then bought by an American firm, and now my personal medical records are in Dallas, Texas. God knows how many times the ownership has changed hands through corporate mergers and buyouts since then. This has been flagged by a number of witnesses, and you in your presentation, but the cross-border jurisdictional problem of trying to protect Canadian information in other people's hands in other jurisdictions. I don't know if there's enough measures that you could possibly take to be able to give me any confidence that they're not selling my information to some drug company who's then going to bombard or, use that for advertising or, who knows what.
Well, there are several things, Mr. Chairman, that can be done. First of all, in the example that the honourable member gave, I believe that is your health information you would have given to the Manitoba government. So the Manitoba government can issue guidelines it may have, like the federal government, and suggest that there is a scale of sensitivity, and the most sensitive things the government may wish either its contractors to be bound by very, very strict contractual clauses or the data to be processed in Canada. Like you'll remember the Lockheed Martin Stats Can
remember very well, yes.
Discussion of some years ago. That's in the private sector. In the public sector, we come back to the responsibility principle that I was discussing with the previous honourable member, and we encourage organizations to bind those to whom they give personal information with very strict contractual clauses that allow them to do more than probably a law in the other country would, which is to go in and check, to do audits, to hold the other party responsible for damages. So it's quite a useful tool, I think. I don't know if, may I ask Assistant Commissioner Black has worked on some of these cases?
Well, when we investigated the complaint we had about CIBC Visa, where the information does in fact flow into the United States, what we discovered is that CIBC had they had done everything that they could do to protect the information. It dealt with, the agreement that they had with the company that they outsourced to, dealt with safeguards, how the information could be used, as in not used, not disclosed, all that sort of thing. So they had taken all of the appropriate steps, and the law, in fact, requires that to happen. If you're going to outsource, whether it's to the United States or to India or wherever you're going, you are ultimately responsible, and if you're ultimately responsible, you do the best you can to protect yourself as the organization in Canada, so that we can't come along and say, we hold you responsible for the fact that this information was sold or, what have you.
Well, fair enough.
First of all, I'd like to say I'm pleased that you feel that PEPITA is working well. There's a couple of things, though, that I'd like to ask to you. One of the issues that's been raised previously, and we've really just started, we've had, 2 or 3 sessions of people coming to talk to us. And one of the issues that was raised was the issue of personal information, the definition of personal information in the legislation, and whether or not it should exclude work product information. And you referred briefly to that in your report or in the statement that you made to us, third paragraph on page 2. And you've said you've addressed this issue by adopting a case-by-case approach to assessing whether or not the information in question is about the individual. I gather from what you're saying is that you don't believe that there should be a change in the definition, or am I misinterpreting what you're saying?
No. Mr. Chairman, that is correct. The honourable member has exactly stated what our position is. We raise it, but our preference is that we leave PEPITA as it is. I believe this issue was looked at in 2000. It is a flexible definition. We have, in some of the decisions, made by the Privacy Commissioner. We have dealt with the issue of work product, that in very obvious situations that it is not covered by the Act, but in situations where the information is of a more personal type, more of a revealing type, that the Act could cover it. And this is an important issue for many people. I'm concerned, Mr. Chairman, that if we go to a definition, that this definition will hamper our attempts to minimize workplace surveillance as we go on, and increasingly it's easy for employers to set up video cameras and monitor their employees in all kinds of ways, that this will hamper our efforts to limit that kind of surveillance to what is necessary. So I think for the moment that the status quo is reasonably satisfactory.
Well, I guess the reason I asked that question, Madam Commissioner, is this matter did go before the federal court. I think it was involving a competitor
It was never
challenging.
paid, was it?
No, it was,
Do you know what I'm talking about?
Yes, yes, I do.
Yeah.
Yes.
And so,
it was discontinued.
you asked the question, not me, but one asks the question, whether or not, A, does this give the Commission too much discretion to decide on a case-by-case approach, I suppose, number one, and secondly, should the public require more certainty so that they know exactly what they should and should not do, as opposed to leaving it to the Commission to decide on a case-by-case approach?
Yes. My recollection of that case that went to the federal court was that it was discontinued. It didn't really decide the issue. Well, I think, honourable member, that's something for this committee to decide.
Okay.
I'm talking
well, maybe when
to
you come back, you'll be able to tell us, because I'm sure this topic's going to be raised in the future by individuals, and I would appreciate if you do come back again, and I hope you do, that this will be at the top of your list, because it seems to be it's one of the issues that's been dealt with. One of the other issues, Mr. Chairman, is the issue of solicitor and client privilege. I'm not familiar with this case that you've spoken of, this Blood Tribe case. Are you saying the Commission should be allowed to go beyond solicitor and client privilege? Is that what you're saying?
Yes, Mr. Chairman, that's what we're saying, and we do in the Privacy Act.
You see, I always thought as to whether documents are solicitor and client, or are you saying you should have right to that information whether the solicitor or client privilege or not? Is that what you're saying?
Yes, we're saying that in the course of our investigations, we have to be able to look at all the documents that are relevant to our investigation.
You're going to get the law societies and the Canadian Bar Association all excited.
I think they already are, Mr. Chairman. Yeah.
Worry about that later.
With your consultation, yeah, I know, and I'm sure someone's going to come and challenge you on that. I must say, there's a lot of lawyers in this room that I can't believe aren't excited as well. I mean, it's quite a major.
It's a fundamental
I don't know of any situation, if there are, there's very few of them, where you have you can simply go beyond solicitor-client privilege. It's quite a major statement.
Well, it is, but the first level of court agreed with us, so it's not patently
but
unreasonable.
the second level didn't.
Yeah, well, we may take it to a third level.
Indeed. Okay, there you go, Mr. Chairman. With respect to your consultations of the 12 issues,
Yes.
You're going to give us those, are you? You mentioned 12 issues that you had. Is that somewhere in the documentation that we have?
You have a resume of, yes, the answers that came back. Yes, background information. It's a document that was given to this committee. It's some 36 pages. Okay. And you have a resume of the positions.
Okay. Well, one of the issues that I'm interested in is to whether PPIDA is doing enough to facilitate small business.
That's an excellent question, Mr. Chairman. Most of our complaints are against the large organizations that are the federally regulated organizations. In some provinces, of course, we don't see the small business because it's the provincial laws that applies. Certainly when PEPITA first came, we had extensive meetings, particularly the Assistant Privacy Commissioner responsible for PEPITA had extensive meetings with representatives of small business. We consulted them as to what they would need. We are currently working with our enhanced budget that was granted to us. We're working on an interactive tool for businesses for implementation of PEPITA with small businesses in mind that don't have a lot of money to invest in privacy compliance. So the short answer, Mr. Chairman, is you're probably right that we're not doing enough, but we're trying to do more.
No, I didn't say that. I was just asking
Well,
whether you were or not. And I guess now that you've said that you're probably not, how do you feel that you can? How can the legislation be changed to assist small business more?
I wasn't thinking of that, Mr. Chairman. I'm just thinking that the burdens of compliance generally tends to fall quite harshly on small businesses.
Yeah.
I think so in that sense, that's my own personal opinion. I would think that, you know, we may not be doing enough, but I mentioned this interactive video that would be a learning tool and that would is designed for small businesses that don't have the money to go out and hire privacy consultants and so on the way the big businesses do.
Before we go on to our next round, just to be crystal clear on your position with respect to solicitor and client privilege, in your opening remarks, you said, and I'm quoting you, "It effectively allows organizations to shield information from our investigators with no independent verification that the documents in question do in fact contain information subject to solicitor-client privilege." There's a major difference between saying we should be able to look at the documents to determine whether or not they are subject to solicitor and client privilege, and saying we should have access to all documents, even those that are subject to solicitor and client privilege. Do you understand the difference of what I'm pointing out, and which is your position?
Well, I think it would involve both. Our position is that we should be able to look at the documents to see if they would be subject to a solicitor-client privilege, and if not, then to examine them to see if they have personal information relevant to the investigation.
Yeah, clearly, but if so, what if your investigation finds that they are subject to solicitor and client privilege?
Well, then, you know, I think that would be it. You know?
We'll get to that. Yes, go ahead.
Put this in context. I mean, just to take the fact situation in Blood Tribe, our complaint came from an employee of Blood Tribe, and Blood Tribe is a federal work under the definition. So we investigated. She wanted access to her personal information held by her employer. And the employer said, well, you can have this, and you can have this, and you can have that, but you can't have, it was just, I don't know, just a few documents that they claimed were privileged. Now, in order for the commissioner to do her job and say, you correctly invoked this exemption to disclosure because you don't have to disclose to your employee a privileged document, we have to be able to go in there and look at that document and say, yes, it is privileged, and you're right, you don't have to disclose it to the complainant. So that's the sort of situation that we're looking at. I mean, it doesn't come up in every case. In fact, it rarely comes up. It's very rare that an organization actually claims the exemption for solicitor-client privilege when faced with an access request.
But I guess what you're basically saying is there should be some mechanism to determine whether or not the claim of solicitor and client privilege is in fact a valid claim.
That's right.
Thank you. Mr. Dhaliwal, please. 5-minute rounds.
Thank you, Mr. Chair. Marlene, you want to go ahead or you want me to go ahead?
If you have questions, go ahead. If not, I've got questions ready.
We'll pass it on to you then.
Thank you.
My time. Thank you.
Thank you. Thank you, Chair, and thank you, Mr. Dhaliwal. Thank you very much for your presentation. I apologize for missing the first part of it. I had not received the information that the committee room had changed, so I was at 371 West Block. I'd like to ask you on 3 issues, and I'll try to be very, very brief in my questions, and if you don't have enough time to respond fully, you know the routine, you can send it on in writing. On the question of the obligation of notification when personal information held by a company, for instance, a credit card company or a bank, has been either lost or stolen, there's a whole issue about the need to have a mandatory requirement to inform the individuals that their personal information has been violated, and that at this point in time, you as Commissioner have no way to penalize companies that do not notify. My question then is that if you're seeking authority to be able to, one, compel companies who hold personal information legally, but from whom this personal information has illegal access to that information has been gained, you're seeking the authority to require the company to inform the people, the individuals whose personal information has been violated, and to have the authority to penalize a company that does not do that. Does that not accord better with the model of Commissioner that has the power to issue executive orders rather than an ombudsman model? That's one. Secondly, on the issue of work product, I think the point that Mr. Tilson raised, that the fact that, notwithstanding the fact that you would prefer to continue on a case-by-case model or of way of dealing with this process of dealing with the issue of is it personal information subject to, worthy of privacy, or is it work product? I think that there is a need, a compelling need. There are companies that deal with personal information, and I think that if we want to ensure that the processes that they put into place are in fact well-founded and they're not going to suddenly be caught up short after possibly months and thousands, in some cases it might be millions of dollars invested into putting into place a process in order to capture legally personal information, treat it, send it out legally, all of that, and then all of a sudden there's a decision that says, oh no, that's wrong, you can't do that, that information or parts of it. I think that if there was a definition, a distinction between personal information that comes under the privacy and work product, with whatever clarifications are needed to ensure that the scope is not too large, that it's sufficiently narrow, but it's very clear, I think that there's a good argument for that. And Mr. Bennett, who came before the committee, Professor Bennett, also was in favor of it, as was the other professor who was here. Third question is again on the issue of the ombudsman model. You have no executory powers. There are models which are not quite ombudsman. It's a mixture, and there is the authority, and there is a way to build into legislation deadlines, delays, in order to ensure that the process for handling the complaints and disposing of them can be done in a very fulsome manner, but a very efficient and quickly, rather than a year or 2 years, etc. So I'd like you to, if you're not prepared at this time, I'd like you to reflect on that. I think that the models in British Columbia and Alberta have provided sufficient information to allow us to move forward.
The members, that took 4 minutes and 45 seconds.
You're welcome, sir. So the Commissioner
could you please, Commissioner, either give us a very brief response to those 3 questions, or perhaps a written response later? If you have any comment on any of the 3?
Yes, what would be most useful to the committee?
Whatever you'd like.
I know.
Well, maybe could I do both, Mr. Chairman? Very briefly to the honourable member. I think the ombudsman, in the current model, we forget that the Privacy Commissioner has a whole series of powers. because they were not used in a consistent way from the beginning. So we are now taking cases to federal court. We're now involved in 12 cases. We have an almost total rate of compliance when we say we're going to take cases to federal court. Federal court, don't remember, can order damages. None of the provincial commissions can order damages. You can make an order. It's the same as our recommendation. Yes, it's a binding order, but it doesn't really put the person in the place they would have been had there not been a privacy breach, because it can't account for damages. I think that's an important issue.
I think I'll stop you there, Commissioner, if you wouldn't mind, and provide written answers
Okay.
to the other two. Thank you.
Certainly.
Mr. Wallace.
There I'm on now. And I'll ask questions and give you a chance to answer. It's come to my attention that there's organizations who like the BC definition of that they have in there. Do you want to comment on the British Columbia?
Work
product. Work product. They understood. Sorry, Mr. Chairman.
Yeah. Certainly, yes. I think the BC definitions, I understand, is well received in BC, and I think you may have the Commissioner himself to comment on that. So I will simply reiterate from the point of view of the protection of privacy that when you go for any definition of work product, it may have the effect of narrowing the protections for other related information related to the person's employment. Secondly, I note that the BC definition does not provide for consultation. In fact, it excludes, as I remember, the work product from the definition of personal information. Another provincial jurisdiction has, in fact, put in a step of consultation of those whose personal information is being collected. I think that's an interesting facet that is not in the BC legislation.
I appreciate that. I'm going to follow up on my colleague's question about the private sector piece. Because I'm new to this and didn't have the experience of being working for a company that was related to this, what is your average cost for this program for a small business? I know you said that you were looking at, with your increased budget, you're looking at ways to better communicate how to implement PPETA as an organization. But what are the costs to small and medium-sized business, if you have a sense of what that is, and do you care?
Well, yes, I certainly care. I care that the law be as easy to apply as possible, because privacy is a fundamental right in this country, and because Parliament's adopted this law, I care whether it be practical and easy to apply. I'll just say before, if I may, Mr. Chairman, asking the Assistant Commissioner, who deals very closely with a lot of these cases, to give some examples of how small business try to comply. Parliament, as I understand, deliberately in 2000 chose a very light and flexible regulatory system. And I'm saying this to the honourable member because it could have chosen much heavier systems, for example, the British system, where you have to register your databases with the UK Commissioner every year and then pay a registration fee, and that's how the UK Commissioner, in fact, finances his office. But here in Canada, we just said, this is the law, you're expected to comply with it, and unless there is a complaint or the Privacy Commission does an audit or something like that, we will presume, like most of the laws of this country, that you are in compliance with it. So it was supposed to be a light law. I don't know if...
Well, as you probably know, the law is based on the CSA Model Code for the Protection of Personal Information, which was developed as a voluntary instrument by, various stakeholders, including business. It's a standard, and it's a management standard, so it's quite easy to apply. It wasn't developed as a law for big business or little business. It kind of works for everybody. If you're a small business, your privacy policy can be one page. If you're a huge organization, your privacy policy is probably thicker than this binder. That sort of thing. So it's not difficult for small business to comply with the law. A lot of them, are trying to comply, and I think that part of where we could possibly do a bit better is in education and working with small business.
And during your budget consultations, which you were here a few weeks ago on, that was part of the process. That money, that extra money, is to help promote PETA and how to get up to speed on that. Is that an accurate statement?
Yes.
And when would we expect that to be available to the public?
In the course of this winter, I think, Mr. Chairman.
Okay. Thank you, Mr. Chairman.
Thank you. Monsieur Laforêt, s'il vous plaît.
Bonjour.
Good afternoon. You said towards the end that it is possible to improve the Act. You made a few suggestions. However, we heard several witnesses tell us that your office did not have the power to make orders, that it complicated the process for them post-investigation. In Alberta and British Columbia, commissioners do have the power to make orders. You said that you did not ask for additional powers, so I don't quite understand why you say that at this point you might not want additional powers. Well, actually, it is a very timely. I believe that the Act has not really been implemented as it should have been until April 1st of this year, when we were given a budget commensurate with our mandate. And from that time on, our situation was more stable, and we had a strategy, we had a plan which was consistent and took into account the needs of both parties. Previously, before, it was very erratic, and there was a lot of upheaval within the Office of the Privacy Commissioner. However, I have an excellent staff to support me. I've already said that, with one exception, all the companies with whom we disagreed about the interpretation of the Act, whom we told that the complainant had a good point and that the company had to bring about redress measures, and when we said that we would bring the case before the federal court, every single one of these companies, except for one, agreed with our position. I also have a power to conduct investigations. You may have read in the newspapers that there is a company which is contesting our power to conduct investigations. This is a huge power we have. We can ask for damages. We could ask for redress before the federal court. Does that become binding? Yes, it becomes binding in a court ruling. So if you look at the purpose of the Act, which is to address complaints, I don't think the point of an Act is to make orders. I think the purpose of an Act is to get people to comply with the Act. And if you look closely at the record of this Act, under the complaints process, you'll see that there is a high degree of compliance, except for a very few cases, such as the Blood Tribe case. So the problem is not so much how much we deal with complaints. I don't think it's any less efficient than the legal process. And I have administered a court in Quebec, so I know what I'm talking about. There can be huge legal complications, and the court process is a lot slower than we would like it to be. So again, the problem is not how we process complaints. It's everything which does not fall under the complaints process. So you're not asking for new powers right now. You're just saying that we have to choose our time. What you're asking for is that the whole process surrounding how we deal with complaints needs to be improved. That's right. I have strong powers. I haven't been commissioner for a very long time yet, and as you know, in the first years of my mandate, really, I had to reorganize the office. But I have very significant powers. Give me a little more time to exercise these powers, and in 5 years, you will be able to see whether these powers got the job done. Thank you very much. That answers my questions.
Thank you for coming here again. I got to say that when you and I first spoke about your job, Madam Commissioner, that it certainly was an enlightenment as far as on a personal basis, because I was a small business owner prior to this, and I got to tell you, it struck terror into all of our hearts when the mandate came down. And when I listened to the testimony, it appears to me that you don't really have a heavy-handed approach unless there's cause or if there's violation. Am I correct in assuming that?
Yes, the law is a flexible, a fairly light law, but if there is a complaint, we investigate that complaint until there is a settlement or we say it's not founded. So, you know, we're not letting people at this point just, we're saying well-founded and walk away. Sometimes I read that the Privacy Commissioner says something that's well-founded and then nothing happens. Well, that may have been true in the past. For over a year now, if it's well-founded, then we are ready to go to court to hold up our interpretation of the law. And we've had virtually total compliance on this. But it's very few cases, honourable members. So in that sense, you know, it's
but somebody has to initiate a complaint, first of all.
That's right.
So, and I think my colleague was alluding to that just his prior question. As you move forward, have you thought possibly about portraying that message? Because again, I'm thinking about the small business person that when he looks at the mountain of paperwork and looking at all this new tasks that are going to be put in front of them, that maybe if we could convey to them that this is what we don't want you to do, and so you've got to fall into these guidelines so that you don't break the law, that you don't offend and, as somebody said, violate somebody's privacy. Mm-hmm. Is that something that possibly you're going to look at the next stage, so that when we so that the smaller business owner understands? I really don't think they understood what the as I didn't. What was the true nature of the legislation?
Yes, Mr. Chairman, the honourable member is completely right. In January the 1st, 2004, there were some amazing misinterpretations of PEPITA that were circulating, and I think there was a sense of panic and so on. And of course, a lot of that was the fact that the office had been in such upheaval and hadn't done what ideally it would have done, although it did consult a small business. Yes, we have identified small business as a very important target for public education, and I must say that I don't think that a heavy hand should be brought in this kind of issue to small business. I think we have major players. Most of our personal information is with the major players in this organization. I would certainly concentrate my attention on them first.
I've got a few minutes yet, Mr. Chair. 2 minutes. As I said, and once it was made clear what the objective was, then it all makes sense. And I think most people would fall into the same category that I was in. Do you have inspectors that are out in the field and checking for compliance?
No, we don't have inspectors. We have auditors.
You have auditors.
But we have to have reasonable grounds to believe there's a problem. So we have to have noticed something. But yes, we have 2 cases where we've sent our auditors in. But this is not small business, I may say. Yes.
And is it probably the biggest concern is and I think Mr. Martin alluded to that as well too. When a corporation is a takeover and that crosses borders, is that your biggest area of concern when you have those takeovers and then you really don't know what's going to happen to that information?
Well, that has to do with being able to share personal information in the case of a sale. Is that what you're referring to?
Any information, anything that could be used for, well, like Mr. Martin said, your health. If for instance, you had to buy life insurance, and my life insurance company were transferred to another country, they could make it difficult for me to buy auto insurance or something like that. Is that an area of concern that you've...
Well, yes, and I think the Assistant Commissioner, perhaps it's the same issue that she was giving some examples of. Yes, we then require of those companies who may be sending their information outside the country that they hold those to whom they are sending it to Canadian standards, so that it would not affect you in any more negative way than were it completely treated in Canada.
And you have jurisdiction over those companies if they're outside of our borders?
No, we have jurisdiction, and this is the hook, and this is the interesting part of it. Through this mechanism, we have jurisdiction over the Canadian companies because it has a presence or a real and substantial link is the legal test in Canada. Because as you know, in the privacy world, there are some countries that say their legislation has extraterritorial reach, and on the other hand, Canadian law doesn't usually run except in Canada and so on. So the surest thing is the companies here are responsible for how they sent the information out.
Okay, thank you.
We have Mr. Martin, followed by Mr. Dhaliwal and Mr. Tilson. Mr. Martin.
Thank you, Chair. I'm just reading a letter from the Assistant Deputy Minister of Industry pointing out that a organization in the UK ranked Canada's privacy regime as tied with Germany as the best in the world. I think that's something to be proud of. But in contrast to that, or building off that point, I'm horrified of what I'm learning now as to what might be the real threats to privacy and the next generation of privacy issues, specifically the RFID information. That I've only heard of this in the last few months. Canadians, I don't think, are aware of this, the idea that you can implant a chip in cards or in people and read it from a distance quite easily. Somebody said, how would you feel if the underwear you were wearing was helping to track your movements around the city? That's not inconceivable with this technology. So I guess I'd ask to use what little time we have if you could speak to that, what your office is aware of and what you can recommend to us to get on top of that next generation stuff. And specifically, I understand there was some grant money given out to an organization to do a study by the Office of the Privacy Commissioner on this issue, or my notes here say that there has been. Well, actually, no, it's a question. Is there any funded research going on, sponsored by the OPC, on our FID? And if not, should we not perhaps think of that?
Teresa Scasis.
Yes, the Assistant Privacy Commissioner. Could I ask her to speak to the research that was done a couple of years ago, Honourable Member?
I don't have the details at my fingertips, but yes, we did fund one of the universities. I think it was Dalhousie Law in conjunction with their computer engineering school to do. They came with a project on studying RFID.
What's the status of that study? Do you know, Ms. Black?
The status of it, as in...
Is it underway, or is it...
Oh, no, it's completed. They did provide us with a paper on it.
Perhaps we could be... Perhaps you could circulate
if you would like a copy of the paper, absolutely. I mean, there is a fair amount of... not so much disinformation, but sort of fear out there about ARFIDs and what they're capable of doing, and
ARFIDs.
ARFIDs, yes, ARFIDs. Right now there's a real limited use of them, but you're right.
Mexico
there's
City
a whole brave new world of ARFIDs on its way in things like credit cards. There are, some astounding instances. I know that apparently there was a bar in Barcelona, Spain, for example, an ARFID can be like the size of a grain of rice, and you can have it embedded under your skin. And it's scary to some of us, and other people say, gee, what a great idea, because I can go in and I don't have to carry my wallet and my ID and all of that stuff, and I just, they scan my, when I get a drink or whatever. You have to face the issue of people are often willing to sacrifice a fair amount of privacy for convenience. ARFIDs in credit cards, for example, will probably bring us a new level of security with credit cards. Because they're sort of maybe chip enabled and passwords and stuff like that. We are working on ARFID guidelines, which will be posted, I believe, on our website fairly soon, sometime this winter. There's information on ARFIDs on the website of the Information Privacy Commissioner of Ontario. There's a fair amount of information out there, but we will provide you with whatever we can in that.
Great, thank you.
This hearing is being televised, and hopefully there will be some people who look at it, and they may not know what an ARFID is. Would you help them out?
An ARFID is a radio frequency identification device. There are two types, active and passive. Some can only be read when they're put near a reader, and some actually emit a little signal. I don't know if you buy books at Chapters, but occasionally a little square piece of sort of paper will fall out of a Chapters book, and it's got sort of a little kind of designy thing in it. That's an ARFID. If you fly through the airport in Hong Kong, your luggage is tracked by an ARFID. They stick it on your luggage, and they can track it through the airport. They're quite it's being used a lot at the wholesale level to track shipments of goods from the factory to the distributor.
Thank you very much. Mr. Dalrymple.
Thank you, Mr. Chair, and thank you, Madam Commissioner, and also the Assistant Commissioner here. This work product related issue is coming again and again in these proceedings. Could you explain a clearly difference between the work product and a personal information when it comes to the medical field?
In the medical field?
Medical records.
Well, personal information in medical records would be, let's say, the contents of my file, the medical details about me, my state of health, the results of my latest tests, things like this. This is all personal information related to me. In the case where the Privacy Commissioner decided that some alleged personal information was, in fact, a work product, as I remember, it had to do with the prescribing patterns of doctors.
Right.
So it wasn't personally about the doctor, him or herself, like the contents of my medical file would be about me, but rather the information about them that they displayed through their professional activity.
So that you would call it a work-related product then, right?
It was decided that it was not personal information.
It wasn't. So would you have any difficulty then incorporating that into the PIPEDA?
Well, as I said, it's always easier to define things in a particular fact context. This is not an issue that you mentioned that it came up again and again. It doesn't come up very often in our complaints. I don't know how many complaints we've had that would deal with that.
A mere handful.
A handful, you know. This is not an issue that, you know, dominates our complaints, but one of the issues that does come up a lot in our complaints, and one of the areas where we have active concern, for example, about the use of RFIDs or other ways of surveilling people, is in workplace surveillance. Increasingly, those of us that work for anybody are going to be subjected to increasing surveillance. So yes, you could put a definition in the Act. We're just cautioning you that any definition may have this indirect effect of, with new forms of technological surveillance coming, providing less protection for workers.
Thank you.
Kind enough, Commissioner, when you come back, to give us a concrete example of what you're talking about. I'm having a great deal of difficulty making the leap between what Mr. Dhaliwal was talking about, which is the prescribing habits of doctors, and how that would, if there was a definition in the Act, how that would somehow impact on the privacy of employees in a washroom in a factory. So if you could help us out by giving us some concrete example how the one follows the other, because while it may not be a major one of the 1,400 complaints that you've received, it has been brought up by virtually every witness, and I believe it will be brought up by other witnesses. So clearly it's of some concern to some businesses out there, and they'll be looking to us to make some kind of recommendation. So if you could help me with how you figure the one has anything to do with the other and help the committee, then that would be a great service to us. Yes, Mr. Allen.
For the chair, like when we have that information, because most of that information in these days is used for research and development purposes, right? When that information, for example, the prescribing pattern of the doctors, like how they prescribe the medicine, if that is used for research purposes, would you still call it as would that still fall under the personal information, or it still will be for the, if it's for the business purposes, then fall under the PIPEDA anyways, right?
Yes, it's at the time the information is generated with the organizations that it's qualified. It's the circumstances in which it's generated that lead to the definition. And then it may be, for example, anonymized afterwards, and then it isn't personal information for various points. So we'll come up with an example.
Thank you very much. On that point, though, you mentioned that the Privacy Commissioner had made a ruling. Are you bound by that ruling, or could you change it as the new Privacy Commissioner, number one? Number two, even if you confirmed it, it's my understanding that it's not binding on the federal court, whereas a definition in statute clearly would be.
You're right. The Ombudsman's conclusions are not binding on a federal court, and certainly being an Ombudsman, one has a certain amount of latitude in conclusions, but as I think one of the honourable members said, it's always a good idea to provide predictability. So we try as much as possible to provide a continuous line of reasoning in our conclusions.
But just to be clear, you could overrule a previous commissioner if you so chose.
Technically, yes, I could, because I'm not bound, because it's not binding really on anybody. It's an opinion.
Right.
Yes.
Thank you. Okay, Mr. Tilson.
Yes, Mr. Chairman, one of my colleagues asked a question, I think it was Madame Lavallée, and your response to her question was the issue of transferring a file to another jurisdiction, that you could indeed transfer a file to another jurisdiction. I'd like you to talk a little bit about that. Are you telling me that you could conceivably transfer a file to one of the European states or to the United States? Is that what you meant by that?
Well, that I could as Privacy Commissioner?
Yeah.
No, I don't think I can
you'd
now.
be breaking your own law.
Well, that's what we think. Although in the consultation, it's interesting, many people responded that the Privacy Commissioner should do whatever is in the public interest, and they would take a generous view of this. I don't see that it's clear in the law, and in fact, I would think the law says the contrary, that I can't transfer a file to the EU, for example.
No.
And I'm saying in the state of the world that I think I should be able to if the circumstance warrants it. I know the Federal Trade Commission is currently asking for the same kind of powers because it's very hard to follow, the data trail now.
Would you have a definition for that as to what circumstances that you would do that? I mean, it gets back to the issue of the earlier question that I asked on personal information.
Mm-hmm.
In other words, you look at everything on a case-by-case situation. And I suppose the same would be for you'd look at a case-by-case situation as to whether or not you could transfer a file to another jurisdiction.
Mm-hmm.
I would think that to serve the best interests of the country, we'd want a specific definition as to if you do it. And quite frankly, I don't see how you could do it because you'd be breaking the law.
I don't do it, honourable member. So.
But I mean, so I must have misinterpreted what you said. You thought that there might be circumstances when you could transfer a file?
Perhaps I wasn't clear. There may be circumstances. In fact, one could think now that there are circumstances where it would be very useful for me, as a privacy commissioner, to be able to transfer a file to one of my a similar organization in another jurisdiction. Under wording something like, because you asked for wording, honourable member, for a complete and satisfactory resolution of the case, with the consent of the individual, of course. If I said, well, look, basically you've been a victim of some organizations in the United States. I'll take some cases that are well known, and in fact, this is part of it is before the federal court. But in order to really get some redress, it would be better if the American authorities took up your case. Like, let's say police investigators do, they'll transfer it and, they'll go after it under their own laws. So the Americans then could
Except we're all very proud of our own sovereignty, our own jurisdiction, and not assigning our laws to any other country or our proposals, whether it be privacy or police work.
Well, we are very proud of it, but that pride does not give us the legal right to, for example, investigate in the United States, act as the police. So it's in cases where I couldn't act, which is in many other jurisdictions, in most other jurisdictions, you see. So I would say, well, could you take this over, and vice versa? If they had somebody who was coming against their personal information, they would transfer it to me. Data protection authorities across the world are looking at this. Some of them already have the power. Some of the European ones do because they're in closer contact. And the Federal Trade Commission has got a series of amendments before Congress called the Safe Web Act that would allow them to do that for those reasons, because Americans' information is everywhere.
Okay, Mr. Chairman, I have a question with respect to the electronic payment crime, which is on the increase. In 2004, there was the federal government announced the creation of something called the Cyber Services Task Force. Do you know what that is?
Was that the anti-spam task force?
No.
Okay, we'll move on to something else.
Minutes.
All right.
There's an anti-spam task force. But
Madam Commissioner, following up on Mr. Tilson, you said, and I quote, "I would ask you to consider a specific provision to make it clearer we, I presume the Commissioner,
yes, my office,
have the authority to share information with our international counterparts while cooperating on investigations of mutual interest." That's what you're asking for. So to share information. Personal information is what you mean of Canadians, and you want to be able to share it with international counterparts. Am I reading that correctly?
Yes, and I would like to share it perhaps not only on cases which are of mutual interest, but of cases where it would be in the interest of Canadians that the investigation or the redress be followed up in another jurisdiction.
All right. Madame Jennings, followed by Ms. Yelich.
Thank you. I'd like to come back to the question that my colleague, Mr. Dhaliwal, raised about aggregated prescribing information and the possibility of the necessity for a carve-out and a clearly defined exemption. Mm-hmm. Given the fact that medical advances are proving that we have an increasing number of drug therapies to treat all kinds of health conditions. We have medical practitioners who require information, scientific information, about the impact of certain prescribing profiles. We have researchers who also require this kind of information. Do you not think that it is a possibility to do a very clear carve-out which would provide an exemption for aggregated prescribing information that would not affect the fears that you have of weakening privacy protection for personal information if a definition of work product, for instance, is done, because that would make it so large as to weaken that protection? Mm-hmm. Is that something that you think could be considered?
Well, Mr. Chairman, I think that if the honourable member has a specific type of work product information in mind, that doubtless, it would be possible. I was replying in a generic way for all kinds of work product information. I believe you mentioned
aggregated prescription patterns.
Yes, that could be, if that was probably, I'm saying probably because I haven't done the exercise, specifically carved out, and then it would be fairly clear, then it wouldn't spill over into the other issues of workplace surveillance that I'm concerned about.
Thank you. So I would appreciate if you would look at that and possibly propose an actual carve-out for that specific type of work product information, but it would be specifically aggregated prescribing information. The other point I want to get back to is the CSA standard as a model. Mm-hmm. We've heard from expert witnesses that it's actually a good model because it's, to use the description, a fairly light-handed model that provides a building block from the bottom up. However, when we come to the issue of consent and the definition of consent, there have been studies that have shown that, in fact, a significant number of companies imply consent, and that the way in which they obtain consent may not be as clear to the consumer as one would hope for. And these organizations are recommending that, in fact, the whole issue of consent be tightened up so that it has to be a proactive thing rather than implied. Give you an example, one that I gave, and I'm not sure how much time I have left, Chair. 2 minutes. I receive in the mail an application for a credit card saying that I've been pre-approved for $25,000 credit limit, simply sign off. But there's a whole section on privacy. I scratch it out and handwrite that I consent to the use of my personal information solely for the purpose of obtaining the credit card. I did it as an exercise. The company sent me back an application 3 times. So it was clear that what they wanted to use my information for was more than just issuing me a credit card. Mm-hmm. That's implied consent, and I think that it should be tightened up, but I'd like to hear from you on that.
Consent, of course, is at the heart of the protection of privacy. The problem, as you say, of tightening it up, though, goes to the challenge of trying to provide a definitional basis for all the contexts in which you give consent. And I would think that would be quite a challenge, and I would not be able to, suggest how you would say in such and such situations it's express consent, in other, situations, and so on. In enumerating them, we have provided guidance. We have, suggested the level of consent. We have done many, many conclusions on this, that the more sensitive the information, the more express the consent would be. We've gone into the issues of what a reasonable person would consider appropriate in the circumstances in consent. I think it is not an issue for the law to be tightened up, but for compliance work, that this can be, if you had made a complaint, for example, that would have perhaps allowed us to go into what is the current practice? Why is that company coming back again and again? Doubtless we may have seen them already. We may have never seen them. It would be a chance, an open door. But everybody doesn't have time to, make complaints to the Privacy Commissioner. That's the problem.
Next time I get that and I cross it out and put my expressed and limited consent, if I get back another application, I'll send it to you with a complaint.
Okay, we'd be happy to have it, because one thing that we have done, as I remember, I think the Assistant Commissioner remembers the details of this, but we have said very clearly to organizations, when consumers say no and they don't want to receive things and they don't want to be on mailing lists, you have to respect their wishes. You can't go on and batter them into finally, receiving the material that you want to. I don't know if you'd like to hear about those cases. We had several cases on that.
Yeah.
Okay.
Well, specifically, I mean, as you know, the code says that you can object to the collection, use, or disclosure of any personal information that's not required to provide you with the service. So, in the case of the credit card, what information do they need? How do they need to use it? To whom does it need to be disclosed in order to provide you with the credit card? So it's when it goes beyond that, when they say, well, and when you sign up here, we're going to market you, or we're going to, release your name to, third parties who, we think you might want to hear from. Well, maybe I don't want to hear from them. So it is covered in the law. So it's a question of, again, sort of educating organizations, and the thing that they need to be reminded of constantly is listen to your customer. What does your customer want?
As a consumer or as a client, I wondered what I am signing, what authority I am giving to the people. For instance, the dentist wants you to sign it, and they'll just say, just sign here. It's really nothing. It's just this new Privacy Act that's out there. And I'm thinking, okay, I don't mind signing it, but what are you going to do with the information? Because I don't care if I get extra mail. That isn't what's bothering me, but what are you going to do with it? So I wondered how much authority I am giving them. And you've more or less answered that. I still don't know. I guess it's the individual circumstance. You said 56,000 complaints, inquiries. What's the background of that? Is there a certain sector that has more inquiries in your office than others? I just sort of want to get into perspective what your office is really addressing. And thirdly, because I don't want to come back, I, in my riding, had a car dealership that immediately was very, very upset, where they find it difficult, and everybody thinks car dealers are rich, but these people have to hire somebody else to do the databasing because they want to, and maybe they're overreacting, is going to be my question. Are they overreacting because they want to database not only the customer, but if they've chose a particular color of car, or if they took it for a test drive, all of that information they're trying to database. Now, perhaps they're overreacting, their dealership is. So I just want to know if that's something that sounds unreasonable, that they would be having to hire somebody just to database all this extra information that they require from a customer, because of course I guess when you're dealing with cars you probably are trying to get them on a mailing list to entice them to buy cars or different
Maybe they're over collecting.
I would say they are, but this was actually a directive from their parent company. But I just wondered about that, and I actually had a letter to you, and perhaps I should get that letter again, them describing just how cumbersome it was and the fact that they felt they had to, in order to protect themselves. That's how paranoid they are, and I think you're right. The communications is quite low on understanding what you have to do to protect yourself from, from anyone who might take you to court. So back to the $56,000. I'm just curious, and then I will. Thank you.
I don't have the breakdown here of inquiries.
Just ballpark.
But, most of the complaints are against financial institutions because they are regulated by the federal government. We all have, how many bank accounts do we have on an average? Probably 4 or 5 per Canadian. So, there's all the mortgages and all the amount of personal information that goes around financial institutions, including credit card companies. That is the first major sector. Then we have insurance companies. Again, because they handle a lot of personal information. We have transportation, because the federal government regulates transportation, particularly, I guess, airline transportation. It requires a lot of personal information. And telecommunications. Once again, that brings us into phone companies and cable companies and so on that, again, are increasingly linked up with other suppliers and that's basically the picture.
Okay, thank you very much. And I was just wondering, I want to go back to my first question. Is there such a thing as reverse onus or burden of proof? If I went and signed something and then I found out that I wasn't happy they used my name in something, does that responsibility, can I take that inquire, or can I lay a charge against that company if I thought I really didn't think that they, would the burden of proof be to me?
I would say you can, but I'll let the assistant.
If you sign something and then you change your mind, you have the right to withdraw your consent.
So you have to do it that way.
Quite often organizations don't listen to someone who tries to withdraw consent. They may explain to you that they can no longer provide you with a service if you withdraw consent, but in a lot of cases, say for third-party marketing or something like that, withdraw your consent. If they don't listen to you, then by all means complain.
I guess I was just wondering, sometimes you don't know what you've signed until you...
Until it,
it comes up. I do wonder if... All right, thank you very much.
You can change your mind.
Just a couple of questions, if I may. One of the roles of the Privacy Commissioner under PIPEDA is education and information, as it is under the Privacy Act. And I heard a startling statement at last Wednesday's meeting made by Mr. Richard Rosenberg, President of the British Columbia Freedom of Information and Privacy Association. And I wanted to quote it for you and ask for your comments. Quote, "Second, a much more effective education function is required. The OPC could serve a more effective role than it has up to now, namely to bring the office and its role under PIPEDA to the attention of the Canadian public. In my classes and talks, I have rarely found anyone who knows about Canada's privacy law, his or her rights under the law, the existence of the OPC, the current Privacy Commissioner, or the activities of the office. I think a survey commissioned by the Office of the Privacy Commissioner in March of this year showed that something like 8% of Canadians had heard of PIPEDA. So clearly, if you're not aware of laws protecting you, it's going to be hard to take advantage of the protection that they provide," unquote. I'd like to give you the opportunity to respond.
Thank you very much, Mr. Chairman. You may remember that in the submission that we made last fall to the Special Parliamentary Review Panel, we met with your committee 2 weeks ago on our budget. that a good part of the increase in the budget was because we realized that we were not resourced and able to meet the public education challenge. We have been since the 1st of April, and I gave you some examples of the increase then in our outreach and our visibility, notably through the media and through the website. So I think for the past, Mr. Rosenberg, that you're citing is correct, but we are aware of this and we're taking steps as fast as we can in order to increase knowledge and awareness of PEPITA.
Thank you. Now, you initiated a consultation process and you've told us about it. I just wanted to know to what extent you received contributions and feedback to that consultation process from private sector organizations, as distinct from government and the usual suspects, if I could put it that way. Specifically private sector. I think there was something like 70 people or 70 organizations that responded to you, something like that. Of those, how many would have been private sector organizations?
Okay. If I may, we had 63, Mr. Chairman. We had 42 from a group that goes, it's kind of a big group, law firms, financial institutions, unions, universities, industry, and professional associations. It's not really broken down private and public sector, but I think we have a good response. Just looking at them, I would say it's 50% or more from the private sector. Clearly,
I think it would be higher than that. Yeah.
Okay.
Quite a.
Thank you. Now, I also understand that you were a former privacy commissioner in Quebec. And I'm just wondering if you could, given that you were, and I think that regime has order-making power, does it not? And we've been talking about this earlier, and you've asked not to have order-making power. And I'm curious, given that you were the privacy commissioner in a jurisdiction where you had order-making power, so you've had a taste of it, if I could put it that way. How is it that you've come over to the side that says, no, I don't want that power, I'm happy with what I've got?
Mr. Chairman, if I may just clarify, I'm not saying no, I don't think that to have an efficient privacy regime, you should never have order-making power. I'm just saying at this point, I think that the wisest thing Parliament could do is let the office go on with the powers that in its act, because it hasn't finished using those powers, rather than turning everything upside down by trying to, you'd have to completely redraw the legislation. My experience is that tribunals have their own challenges, notably the challenge of managing the delays of parties. If they're not properly resourced, you have to manage the parties. You have to manage the availability of those who decide, the presentations of the decisions, and so on. So there are, perhaps for people who haven't worked in tribunals, it seems very quick. We'll just make an order. If you can't rule on damages in order to get your order enforced, then usually one of the parties then has to go on to the superior court of the local jurisdiction. So it's not because you've got binding order-making power. It may depend on the legislation that it's necessarily enforced. So you have no damages. You may also be in a very long, drawn-out process, because one of the parties may take you to judicial review during the hearing. So I think before this is seen as the panacea in all situations, that we look at exactly what happens in most tribunals. What is their assortment of powers? What are the elements that make them efficient or not? And certainly the ability for us to go to the federal court, I think, is a great advantage. The federal court is a prestigious court whose orders will be obeyed and that has the means of enforcing its orders, unlike many administrative tribunals, depending on their design.
Thank you, Commissioner. Mr. Peterson, did you have a question?
Chairman. What is your sense of how the the Quebec and the British Columbia commissions are operating? Because they have order-making power. Do you think they're hampered by not having order-making power? Or by having order-making power?
No, I don't think they're hampered. I know when I was in Quebec, Quebec is very proud of it. It was the first private sector legislation. I think if you have a law that's set up with order-making power in the cases of those two provinces, I think it's working well in those two provinces within that constituency. But I think that's one thing to say it's working well there. It's another thing to take a law that hasn't yet been fully applied and to say, well, after 5 years, let's, start again. And that is what I am saying. You must also be mindful, or doubtless you know, Mr. Chairman, that the model of the Ombudsman was chosen because that is the model upon which, or with which, the Privacy Commissioner enforces public sector legislation. It is also the model for the Information Commissioner. It is the model for the Official Languages Commissioner. So, and that is why, because it is this unique federal model, that it was chosen for PEPITA, because it was the available model. And to change it at this point, I think, would not be, would be very detrimental to the enforcement of private sector privacy in Canada.
You ever had a case where you just couldn't get the results that you wanted in a timely manner, and therefore you would have wanted to have that order-making power?
Not for the last roughly year and a half, when I decided that from now on people complied with our opinions or we met in court. No. With the one exception of the case that's now before court, or there's things like Blood Tribe where we say, okay, we don't agree, we go to court, fine, we each have got a level of court to agree with us, and it's on. But no, since I've started doing that, no. I think the issue is just how fast we can push through the investigations. But most of our cases are settled, Mr. Chairman. If you look at our statistics, they're mostly settled. And those that aren't, we'll sit down and discuss it. But if we really think we're right, we'll we're prepared to back our word, and we haven't had many challenges.
Thank you.
Mr. Tilson.
Thank you, Mr. Chairman. We talked about the order-making powers and comparing, I guess, listening to your experience as the Quebec Commissioner. Are there other areas in your experience as being the Quebec Commissioner that you think could be used in the federal legislation?
No, he doesn't like this nation.
That is not currently in the federal legislation.
I haven't really looked at the. I'd have to go back on and
back in time.
Look and see if there were any aspects. The laws are fairly similar. The Quebec legislation now is the disadvantage of being the first legislation that was written. So there were things I think that are clearer in PEPITA now, clearer in the BC and Alberta. And the two laws are substantially similar, so I can't really think of any, any advantage. Of course, it's a different model. It's a model. It's an administrative tribunal model. So everything, once it goes to court, there's a roll. So of course, all the observers and experts look at the roll and see who's on the roll. But that comes with the model.
Thank you.
Thank you, Madam Commissioner. And you are in a very unique position because you've been able to sit in both chairs with different powers. And so if something does come to you before your next appearance before us, we'd certainly appreciate it if you quantified it for us and gave us the benefit of that dual experience, which I don't think anyone else has. Thank you very much for coming today. We certainly appreciate it. And I just want to remind committee members there will be a meeting on Wednesday from 3:30, and the steering committee will meet next week at some point to discuss the number of witnesses and a work plan with a finite end to it. Once again, thank you so much for coming today. I'm adjourning the meeting.
you.